Welcome everyone to Post-Dobbs Implications for Employers on Abortion and Travel Expense Coverage and Reimbursement. Thank you all so much for joining us. Our moderators for today's call are Chase Cannon and Suzanne Spradley. They will be answering the questions you send through the Q&A today. We will try our best to answer all of your questions, but if for whatever reason we are unable to get to your question today, please follow up with your advisor for further assistance. Today's presentation is being recorded. We will be sharing the recordings in the follow-up email and on the NFP website. If there are any portions of this call that you missed, by Monday, you will receive an email with a link to the full recording. The PowerPoint slides used during this presentation will be shared in the same email. At this time, I'd like to hand over the call to Suzanne Spradley, Senior Vice President and Chief Compliance Officer of Legal and Compliance at NFP. Suzanne, the floor is yours.
Thank you, Amber, and thank you all for joining us on a topic that's certainly been on the foremost of many employers' minds. We are fortunate today to have some excellent attorneys from Proskauer, Jennifer Richtering, and Ivandra Gigante, who have certainly helped NFP over the years, and it's certainly a law firm that we recommend to our clients. And with that, I'll turn it over to Jennifer and Ivandra, and if you would just start with some of your background to give our audience a little bit more information about you.
Great, thanks so much, Suzanne, and let me just pop in here on my video. Thanks so much for having us today. I'm Jennifer Richtering. I'm actually in New Orleans, Louisiana, in our Proskauer office here. My practice is 100% devoted to employee benefits compliance, mostly on the qualified retirement and also health plan side. So this is an issue that we've been getting a lot of questions about, and so we're happy to share sort of what we're thinking about it today with your audience. Ivandra?
Thanks, Jennifer. So my name is Ivandra Gigante. I'm a partner in the New York office of Proskauer in the Labor and Employment Department in particular, specializing in all things employment except not benefits. That's where Jennifer comes in. So I specialize in litigating and counseling clients through all variety of employment matters, whether it be discrimination, harassment, retaliation on any of the protected bases. Did a lot of work in the COVID territory, certainly over the last couple of years. And I'm also very happy to be here today and give you all just a little bit of a primer on what we're hearing on the more employment side than the benefit side of this issue.
Great. All right. So I think we're going to I'll start today talking a little bit about some of, the issues on the benefit side. I'll be honest, I think after the COVID-19 pandemic, I thought we might get a little break from, really novel and unusual employment and benefits issues. But it turns out we actually have brand new issues to navigate in connection with the Supreme Court's decision in Dobbs v. Jackson Women's Health Organization. And so to recap, in Dobbs, the Supreme Court overruled Roe v. Wade. And the immediate impact of that decision is that states can now decide the degree to which they will, either regulate or completely ban abortion. And to that end, a lot of states have either immediately outlawed abortion or significantly reduced the circumstances under which abortion is available. And then on the other side, you also have states strengthening protections for abortion, either by state constitutional amendment or otherwise. And what this means now is we have a very challenging landscape for multi-state employers, because it's not even the case that the laws may be a little bit different from state to state. It really is that the various state laws are diametrically opposed on an issue that people feel very strongly about. So in terms of group health plan coverage for abortion care, thinking about how Dobbs, impacted employer-sponsored group health plans, I think a lot of attention in this area has been focused on travel expenses and what sort of large companies are doing. I think it makes sense to kind of take a step back for a second and think about how Dobbs and the decision actually impacts group health plan coverage of abortion services themselves. The starting point for coverage of abortion and other reproductive services has always depended on whether the plan is fully insured or self-insured. And Dobbs really hasn't changed that question. For fully insured health plans, whether or not the plan covered abortion and the degree to which it covered abortion has always been determined by state insurance mandates. So prior to Dobbs, a handful of states, maybe 4 or 5, actually mandated that private insurance plans include abortion coverage. Probably, on the other side, you had states with varying restrictions about the coverage offered under private insurance plans. So, for example, insurance plans, would only cover abortion in the case of life endangerment or rape and incest, with exceptions for rape and incest. On the self-insured side, those plans are not subject to state insurance laws. So there was always more latitude for what a plan would cover. There was never a mandate to cover abortion care. For example, if you compare it to the Affordable Care Act mandates, which required coverage of preventive services without cost sharing. So that is sort of the background. And if you think about it from that perspective, the Dobbs decision, it did not create a federal mandate whereby group health plans either could or could not cover abortion. What Dobbs did is it removed federal constitutional restrictions on the ability for states to regulate abortion. So from the employer's perspective now, the impact on health coverage is really the fallout from the state law changes, because now that power was returned to the states, the decision really is more, and thinking about this issue is really how residents of different states covered under a multi-state employer's health plan, whether they will or will not have access to abortion care. So for fully insured plans post-Dobbs, the answer is still very similar to what it was like before Dobbs, because if you have a insurance policy written in a state that outlawed abortion after Dobbs, the reasonable assumption is that the state insurance policy will also no longer cover abortion charges. And I think we did get a question about which states have fully insured plans. And when I'm talking about that, I'm referring to a health plan in which you've purchased a certificate of health insurance, and certificates of health insurance are governed by state law. So for example, I'm in Louisiana. If I went to Blue Cross Blue Shield of Louisiana and bought an insurance policy in this state, Louisiana state insurance law would apply. If I'm an employer that self-insures, which means I just pay claims as they come in, I'm not buying a certificate of coverage from Louisiana. So Louisiana state insurance law is not going to apply. So that's the answer to that question. Now, if a state restricted abortion coverage in private insurance plans, it seems like if the state is going to outlaw abortion after Dobbs, it seems like that state insurance law would stay in place. Probably, if you have what I would think would be an unusual situation, which is a more permissive state insurance coverage rule in place prior to Dobbs, it's possible that if post-Dobbs, the state decides to outlaw abortion, the insurance coverage law would also change. Similar to fully insured plans, if you are self-insured, so again, you're not buying a policy of insurance that would be regulated by state law. If you're an employer that self-insures, you're going to maintain, the same latitude that you had prior to Dobbs. So you are going to be able to cover abortion, yes or not, sort of deciding what you decide you want to pay claims for. The complicating factor for a self-funded plan is that you may be covering employees that live in states where abortion is now legal. So that kind of brings up a couple questions. And the first is the impact of these state aid and abet laws. We're going to talk a little bit in more detail later about sort of the interaction between ERISA preemption and a state aid and abet law, and whether they could in fact be enforced against a group health plan. But we'll put a pin in that now, but that's something we'd have to think about when we're talking about a self-insured plan. I think the second question for self-insured plans is going to be a little bit more practical, and that is, will your third-party administrator, so the vendor that sort of manages the claims and prices them for you, are they going to continue to perform claim services for residents of states where abortion is legal, but who travel to have the procedure in a state where it can be legally performed. And one thing to think about is that may create network issues, because you may not necessarily have a network for an employee who's resident in Louisiana. You may not have a network that really can accommodate them, for example, in Colorado. And if you're on an HMO, it's also a little more restricted where that service would be covered. And so this, of course, brings us to a question that's received a lot of focus and a lot of attention in the media, which is that what are we going to do for employees who need to travel to states where the procedure is legal or where they can obtain the medication where legal? And then the question that is sort of unfolded is, well, can the health plan pay for those travel expenses? And so we will now move, I think, to the next slide to talk a little bit about the implications of travel expenses. Now, first, I think the cat has been out of the bag on this one. It is appropriate. Group health plans can pay for travel expenses primarily for an essential to accessing medical care. This is separate from the question of whether a health plan would be required to pay for these travel expenses. There is no mandate that would apply to a self-funded health plan to pay for travel expenses to access abortion care. So this is a permissible benefit under a health plan. It's not required. Now, I guess it's possible that a state insurance mandate could require travel benefits for a fully insured plan, but it's hard to think of a circumstance where abortion would not be legal in a state and the state would also be requiring the insurance coverage to include travel benefits. So when we think about this is a permissive benefit. It is not required. Of course, there are employers who are very focused on this and want to offer travel benefits. So we'll talk a little bit now about what those rules are. The source of these rules is the Internal Revenue Code, and the reason why that's the source is those are the rules to determine which expenses can be paid tax-free from a medical plan. So travel expenses to access medical care can be reimbursed tax-free. And we see this concept probably, if you're familiar with it, I'm guessing it's through centers of excellence, which often if you provide certain transplant services under a health plan, you will require that covered individuals travel to centers of excellence to receive those services. So that's sort of the concept before, and the same principle would apply here. So for employers who want to reimburse travel expenses to access abortion care, this sort of unlocks all these different questions about practical considerations, design considerations. And we have design on the list first, but probably it would be more practical to start with the practical questions, because that's really going to limit what you're able to offer. For fully insured plans, I think the thing that fully insured employers have been running into is that when you've purchased a certificate of coverage that's regulated by state law, you can't necessarily unilaterally add travel benefits to that fully insured plan mid-year. So that means that you may get questions from employees asking, why can't we have travel benefits right away? And the answer is that that's a process that you actually have to work through with state regulators. So some states, some state insurance departments are working to add travel benefits to insured coverage mid-year. But for a fully insured employer, sort of the options are kind of going to be limited with respect at least to working with the insurance company. Now, it's possible for a fully insured employer to add a self-insured reimbursement component to its fully insured health plan. And just that's a lot of words, so we should talk about what those mean. But essentially, you would have purchased an insurance policy that provides major medical coverage to your employees. You may go out and ask your insurance carrier if they can add travel benefits, and the answer to that may be no. So what you can then do as a component of your group health plan is essentially set up an account where you as the employer pay the claims that come in, but all this account is going to do is reimburse travel expenses for people to access reproductive care. Now, from a technical perspective, there are certain rules that you have to comply with to make that separate account work, but that would be the workaround for a fully insured plan that wants to offer travel benefits and does not want to wait for those travel benefits to be added to its fully insured offering. For a self-insured plan, there is, of course, more latitude, and that is obviously true for both the self-insured medical plan as well as an HRA. Once you are in the self-funded space, the question is less about what the insurance carrier can do and becomes more about, well, what do you want to do? And there are some interesting design questions. I think probably the first one is there are some employers who don't really want to put a lot of restrictions and want sort of people just to go off and do what is sort of best for them under the circumstances. And then you have others who, want to put some type of reasonable guardrail on what will and what will not be covered. And if you start thinking about some of this, even putting relatively what you would think would be a relatively simple restriction, which is, okay, you need to travel, we'll reimburse travel, but only to the closest available provider. Some of the questions people have asked is, well, is that going to be closest available as the crow flies? So just in terms of mileage, or is it going to be closest in terms of shortest overall travel distance, including if someone were to fly? So once you start digging into what the restriction will be and what travel expenses you'll reimburse, it gets a little tricky. Another question we received from a lot of employers is whether they can reimburse amounts in excess of the tax code limits that apply. So the tax code limits are these Section 213D limits here that I have on the end of this list. And these are the rules, sort of returning to what we talked about at the beginning. These are the tax code rules that govern how much you can reimburse tax-free. So there's a much lower medical mileage rate for auto travel in this context. It's 22 cents per mile, as it compared to, I think, 66, maybe 62 and a half cents for business travel. And there's also a $50 cap on lodging. So, some employers for whom this is they feel very strongly that this should be reimbursed, they don't necessarily think that these reimbursement limits are necessarily going to make people whole if they have to travel. So then the question becomes, well, what happens if we give them more? Let's say we do a $300 nightly lodging limit. And so then you have to kind of work through, well, first off, any amounts in excess of the tax limits would actually have to be imputed as income to employees. That is going to be an extra layer of reporting that some people may be equipped to do and some may not. It's also possible that unless otherwise, excluded under the terms of any plans, additional taxable compensation can also impact any other type of employee benefit programs like retirement plans that rely on a definition of W-2 comp. There's also a technical issue, sort of I noted here as group health plan issues. There is some IRS guidance out there that suggests if you are reimbursing or permitting taxable reimbursements from a group health plan alongside tax-free reimbursements, that might disqualify all the tax-free reimbursements you make under the plan. I think the short answer is if you look at that IRS guidance, it doesn't seem directly applicable to this type of scenario, but the more rational answer is that any proposed taxable reimbursement arrangement in this space should be carefully reviewed with counsel to make sure it's structured correctly. So I think let's talk next briefly about a couple other options on the next slide. Okay, so account-based group health plans. Our prior slide focused on offering travel benefits as sort of part of a major medical plan offering. It's also possible that travel expenses for medical care can be reimbursed from already existing employee spending accounts. So general purpose health health FSAs can typically reimburse all 213D expenses. So this would qualify up, obviously, to the 213D limit. You cannot do that with a limited purpose health FSA because that's limited to dental and vision. Also, health reimbursement arrangements, we touched on those briefly before. I think we also should note here that it's possible that an employer does not want to add a travel benefit, but also wants to communicate it's okay if you want to reimburse yourselves for travel expenses from already existing account-based plans. So then there's less necessarily to do because you're not setting up a new travel benefit within your major medical plan. You're really educating employees that the existing accounts that they have can be used to reimburse themselves for travel expenses, which is, of course, the same before Dobbs as it was after Dobbs. Nothing has changed. It's really an education piece. One thing I would note here is that, it's possible that some record keepers of these accounts could decline to reimburse employees if they're a resident in a state where abortion is illegal. We've started to see some record keepers and other TPAs request that employers execute indemnification provisions, essentially saying that if they are sued or somehow, if the record keeper is sued or somehow attempted to be held liable under a state law for reimbursing abortion-related travel expenses, that the employer will indemnify them for any costs incurred. So that's, important to think about that issue and make sure you're aligned with your record keeper and TPA on this point. Finally, I wanted to highlight that the landscape here is a little complicated for high deductible health plans with an HSA feature. So as you may know, for someone to be eligible for contributions to a health savings account, they need to have high deductible health plan coverage, and they can't get anything called disqualifying coverage. So that means that they can't get any health coverage before they meet their annual deductible under the high deductible health plan for the year. And so importantly, for people who have employees covered by a high deductible health plan, if they want to reimburse them for travel expenses, those travel expenses reimbursements are going to be predicated on someone reaching their annual deductible for the year. And given how high some of the deductibles are in high deductible health plans, it may be challenging for people to get first dollar coverage of travel expenses. But it's important to make sure you work through the issues on that piece, because I think the last thing in the world anyone wants to do is provide a travel benefit for people and then have to let them know that they're not going to be eligible to make HSA contributions for the year because we violated a very technical tax rule. I think we'll just go to the next slide briefly. And that is related to something that has been getting a fair amount of attention. This relates to mental health parity. This is a federal law that requires that benefits offered for medical and surgical care need to be in parity for benefits offered for mental health and substance abuse. People, employers that have health plans that don't offer any travel benefit, that have been anxious to add a travel benefit just for abortion care, I think the question then becomes, does this comply with parity? Because if we're offering travel benefit to access an abortion, but we're not offering travel benefits to access mental health treatment, are we putting ourselves into a box under the Parity Act? I think it's an interesting question. I think in some instances it's a little theoretical. I think that for a travel benefit where the services are not legal within 100 miles of your residence, it would seem as if you would be able to offer a travel benefit to any service that wasn't legal within 100 miles. And that would sort of cover both your medical surgical, so allowing people to access abortion care, but then also cover you on the mental health parity side, because presumably it would also provide, benefits for covered mental health services that weren't legal within 100 miles. The reason I say it's a little theoretical is it's hard to think of mental health services that would not be legal in this context, like abortion. So moving on quickly, I think we talked about reimbursement of travel expenses through both major medical plans as well as account-based plans like FSAs, and then health reimbursement accounts like HSAs. We've also received questions about whether you don't have to do this through any type of health plan. I think one proposal that sort of made the rounds is whether you can do this through something called an employee assistance plan. And I'll cover EAPs first. This has turned out to be rather academic for some people than a practical option for the reasons I want to talk about. EAPs, I feel we've seen an increase in them during the COVID-19 pandemic. A lot of employers decided to offer some type of mental health counseling or employee referral program, and that is an EAP. An EAP, to the extent that it provides any type of medical care, is going to be an ERISA covered group health plan. Now, any ERISA covered group health plan, or the majority of them, are going to have to comply with ACA rules, which includes first dollar coverage of preventative services and no annual or lifetime caps on essential health benefits. You can, however, structure an EAP as an accepted benefit, which means you don't have to comply with these ACA rules. But you only get to do that if you're not providing significant benefits in the nature of medical care or treatment under the EAP. So the question has become, for people who want to offer a travel benefit through an EAP, whether doing that is going to either constitute significant benefits and sort of blow the accepted benefit exception, or if you look at the travel benefit alongside all the other benefits that are currently being offered under the EAP, whether that's going to tip you over into the significant benefits, into providing what would be considered significant benefits under the EAP. And given that is sort of a factor-based analysis, that it's difficult to tell how one of the agencies would decide, I think a lot of people have sort of moved beyond the EAP as an option. And then finally, this final piece here, this pay-as-you-go reimbursement, I think it's pretty common for employers in this situation to be under pressure to set up something very quickly. And as a result, I think we've received a lot of questions about, well, I don't really have time to think about how this is going to work with the health plan. I just want to pay people and reimburse them. They should just give me the receipts, and we can make people whole that way. And I love speed. So I like the idea of being solution oriented. I think what's tricky here is that this is really a solution of last resort, because it creates really more problems than it solves. And the thing that's very important here is that this type of reimbursement arrangement, where people are just sending you their receipts for travel to go get, abortion care, and you're just reimbursing them, that is technically an ERISA group health plan. But the way this would be structured would mean you wouldn't be intending to comply with any of the rules that actually do in fact apply to ERISA group health plans. And as we're going to talk about a little bit, there's been a lot of heat lately in the press related to companies who've decided to offer travel benefits, claiming that they will be prosecuted under state law for doing so. And one of the stronger defenses to these types of claims is that if the benefit is offered under an ERISA covered group health plan, ERISA in theory would preempt such a state law. But that kind of falls apart if you're just reimbursing people after tax and not complying with any of the ERISA rules, because you may be in a position where you want to assert ERISA preemption in response to such a lawsuit under a state law, but then the prosecutor is going to point to the fact you haven't complied with any of the ERISA rules that actually you should have been complying with as it relates to the group health plan. So I think the after-tax reimbursement, again, it would be fast, but I think it would not give you the benefit of ERISA preemption, which is going to be a valuable tool should you need it. I think also, I don't think I need to go through what the potential challenges would be in having such sensitive information and holding such sensitive information about employee reproductive decisions. It really just opens you up to all sorts of privacy law concerns, that some of which Evandra, I know, we'll talk about in a little bit. So that's sort of the lay of the land on the pay-as-you-go reimbursement and doing it after tax. And then I think to wrap up at least sort of my portion, I think we will also talk briefly a little bit about ERISA preemption and how it is going to impact employer decision making. So ERISA preemption, for those who work in this space, we know it and we love it. ERISA is a federal statute that governs employee benefits and preempts any state laws that relate to employee benefit plans. That means, for the most part, there is a uniform regime of laws that apply to employee benefits. Now, there are two very important exceptions to ERISA preemption, especially in the context of reimbursing travel benefits and abortion. The first is state insurance laws. So state insurance laws are going to not be preempted by ERISA. So returning to sort of the beginning of the presentation, for fully insured plans, the scope of the coverage is always going to be determined by what is allowed under the state insurance law. Another important exception, one of which I've been fortunate not to have to think about too often in my career so far, is that state criminal laws of general applicability are also not necessarily preempted by ERISA. And those two exceptions are very relevant in this post-Dobbs landscape. So let's go to those in the next slide. So first, as I mentioned, state insurance mandates are going to continue to apply. And I included as examples here, I said both private insurance plans and sort of marketplace plans. And the reason I flagged that is the mandate for abortion coverage actually varies depending on the type of plan. So what is required for a private insurance plan under state law may be different than what is required or permitted on, for example, public employee or marketplace plans. So it's important when you're thinking about what is the relevant coverage restriction, that you've correctly identified the type of plan you're looking at. And common coverage restrictions in this space, especially now post-Dobbs, abortion being permitted only in the case of life endangerment, impairment of a major bodily function. On the other hand, we also have coverage mandates. So some states that have a more expanded laws with respect to abortion access, in response to Dobbs, they are actually passing new mandates that would require coverage of abortion without cost sharing. So again, if you are a fully insured health plan, you're going to have to look to your state insurance law, and that would not be preempted by ERISA. So the state criminal laws of general applicability, and this is where we're going to get into a little bit more about the aid and abet laws. State criminal laws of general applicability are not preempted by ERISA. So obviously that means, laws related to larceny, theft, embezzlement would not be preempted, which makes sense. If you have someone, for example, who worked at a health plan and stole money, it doesn't seem necessarily right that the state law that would punish that person under a theft statute, would be preempted by ERISA. What is complicated to predict how, for example, a state criminal law that made it a crime for someone to reimburse the costs of an abortion or reimburse travel benefits for abortion is that Roe v. Wade actually predates ERISA. So although there is some case law in this area looking at when a state criminal law of general applicability would be preempted by ERISA, we don't have any good examples about how state criminal laws related to abortion interacted with ERISA before Roe v. Wade. So that means we really don't have the precedent to make thoughtful predictions about how some of these state laws will play out. And I think the next slide kind of goes through that a little bit more. Right. And so this is probably the topic on which we have received the most questions, apart from we want to reimburse more than $50 per night for lodging, which we've received a lot. So this sort of explains that either in anticipation of the Dobbs ruling or now post-Dobbs, states are passing laws that essentially impose liability on employers that would pay for abortion through a health plan. So the first one up here, this is a civil liability. This is an aid and abet statute. And you'll see that included in the scope of prohibited conduct is reimbursing the costs of an abortion through insurance. And so this type of law extends to a group health plan. Now, the statutes that impose civil liability are not state criminal laws, obviously. So there is an argument that this type of civil liability statute would be preempted by ERISA. So to return to our example, if you are a group health plan and you pay for someone to travel from Texas to Colorado, sort of a civil liability statute, to the extent you were charged or the state tried to impose civil liability on you, the answer would be, well, I'm sorry, but ERISA preempts this state civil law. Of course, the answer is complicated by criminal laws. So criminal laws that impose liability on people or plans that assist or reimburse the costs of an abortion, this starts to feel a lot closer to a state criminal law of general applicability. And what has been very complicated in this space is, although recent sort of aid and abet statutes are actually premised on civil liability, there are a number of pre-Roe abortion bans that also have aid and abet language. And the applicability of those laws is pretty unclear at this point. I know Texas at least is litigating whether it can enforce its pre-Roe ban, both civilly and criminally. So to the extent that an employer is weighing its risk, it's important not only to look at the statutes in force, but also to check whether any pre-Roe ban would potentially prohibit this conduct. And I think finally, sort of, if we're thinking about this issue in the context of today, we're talking about the laws that exist today. And so if you kind of put aside the pre-Roe bans, Texas and Oklahoma have aid and abet statutes that impose civil liability. But it's really hard to make long-term decision-making because a lot of states are thinking about passing laws that would impose civil and criminal liability on people who travel out of state to access an abortion. So any type of decision-making today needs to acknowledge the fact that the law could change, at least the state laws could change pretty drastically in the next few years. And kind of to conclude on this slide, I think many of you may be familiar with a letter that the Texas Freedom Caucus, which is a sort of legislative entity, like group, consortium in Texas, sent to the chair of Sidley Austin, which is a large law firm with offices in Texas. And, the letter was in direct response to Sidley's announcement that it would reimburse travel benefits for Texas-based employees who traveled out of state. And in the letter, the caucus asserted that the pre-row ban applied and that it intended to hold Sidley responsible on that basis. And that's interesting and definitely, is built on the laws that exist today. But the letter also included a really long list of laws that the caucus intended to introduce during the next state legislative session. So I'm not sure if any of those proposals will become law, but I think it gives like a flavor of what's out there and how any sort of prediction in the space of how state laws will interact with ERISA is really difficult to give right now, simply because not only is the applicability of current laws on the books currently changing, but also there could be many different state laws when we, for example, talk about this issue in the next 6 months. So it is a lot for employers to digest. And I think I'll turn you now over to Evandro, who's going to give you even more questions to think about on the employment side.
Yeah, Jennifer, actually, Evandro, before we go over to you, if we could ask you a few questions that certainly we had several that came through related to state law and how you determine which state law is applicable. If it's, where the plan is issued out of, the policy is issued out of in the context of a fully insured plan, is it where a participant resides? If you could speak to that.
Right. So I will share that it's difficult to say with exact certainty. For a state, let's say the policy is written in Colorado where the employer is, but then you have employees based in Texas, and the Texas employee is traveling to Colorado to access the abortion services. I don't think there would be anything in the Colorado policy that would prohibit the reimbursement of the Texas employees' travel or accessing of the abortion services. What is going to be more complicated is if, for example, Texas were to pass a law, criminalizing the Texas state residents travel to Colorado to get the abortion. I mean, at that juncture, I would think that the Texas state law would actually apply to that Texas resident. Does that help? Were there different flavors to that question, Suzanne, that I should go over?
No, I certainly think that helps. So we have another question I have heard from individuals. It relates to abortion via medication and having medication.
Wow. Yeah, that is a complicated question. And part of the reason why it is so tricky is that, well, first off, a lot of states actually have laws that prohibit receiving abortion medication by mail or receiving it via telemedicine. Separately, for some of these prescription drugs that cause abortion, they are regulated by the FDA. And the FDA has now said that you don't necessarily need to take these medications in the presence of a physician. So the FDA has made a separate determination for the first phase of the medication abortion regimen that it does not have to be taken in the presence of a physician. State laws, though, do require that you take that medication in the presence of a physician. So there actually is a lawsuit pending right now in Mississippi where the maker of one of those drugs has sued Mississippi, saying that the FDA rule preempts any contrary state law. As the questioner may know, or you probably know, Suzanne, like medication abortion accounts for a very large percentage of abortions. So having an answer to that question, whether the FDA rule will apply or whether states can impose more significant restrictions than the FDA, is going to be a very significant development in this area. And one, unfortunately, that I don't have a great answer on right now.
And then I think you touched on, and Chase, please add in other questions you think are relevant at this time. But in terms of like if you're offering the travel benefits for certainly for the abortion, you mentioned it in terms of mental health parity, but would you apply the same kind of analysis for other types of benefits, that it must be something that is outlawed in the state, similar to the abortion, in order for there not to be a discriminatory issue?
Right. Right. So I think that's an interesting question. And in part, the decision may be made for you because a lot of, even for self-funded plans, a lot of TPAs are requiring that if you decide to offer travel benefits, you also need to offer it for mental health that's not available within a certain number of miles. So you wouldn't really have the option to offer travel benefits only for abortion. And that's really going to be driven by what your third-party administrator, if you're self-funded, or the insurer is offering. In terms of what I think a successful parity analysis would be, based on the information we have today, I don't think it would be unreasonable to offer a travel benefit for medical services that aren't legal within 100 miles of you, because again, that seems to pick up abortion, but also it would cover any mental health services that weren't illegal, that weren't legal and also covered under the terms of the plan. What becomes a little challenging, though, is thinking of a mental health service that fits those criteria, because it would have to be both, generally accepted with medical standards and covered under the plan, and also not legal within 100 miles. And it's hard to think of good examples of what those would be.
Yeah, thanks, Jennifer. I'll just jump in with, that is a popular question that's come in. And another one relates to privacy.
Right.
And, for the employer, if they're seeing some of this information or getting an employee request or reimbursing, what privacy considerations are there? And does that matter based on the plan structure? I think it probably does, right? And how the requests, like any other claim, are sort of coming in. So if you have a sec to speak to that.
Yeah, I will say that you should do everything within your power to make sure you don't get this information, because it's going to be much simpler for you. If you, for example, are a fully insured plan that is impatient with waiting for your insurance carrier to put a travel benefit in place and decide that you're just going to start reimbursing claims, well, as a fully insured plan, you're probably not set up from a HIPAA perspective to look or house any of this information. So once you have it, then you have to figure out, well, is there a HIPAA compliance officer here? Do we comply with the electronic rules? So it creates a lot of problems. And then separate from HIPAA, there are also state privacy rules that apply. I think Vondra is going to talk about some of the state-specific employment laws that apply once you get information about an employee's reproductive decision-making. But all of that counsels toward finding a solution that does not involve you holding the information yourself and reimbursing those claims. There's just too many potential ways that it could go wrong, at least from my perspective.
Thank you. We'll let Evandro continue, and we'll ask any further questions if we have time at the end.
Great. Thank you.
Good. Thanks, everyone. So I will briefly touch on some employment issues that we've been speaking to our clients about in the wake of the Dobbs decision. So clients have asked, can I grant leave and accommodation requests related to an employee's access to abortion? Must I provide some abortion-related leave, and what are the potential implications? And listen, I think by and large, we're going to go through these answers in some more detail, but employers generally, have the right to grant leave and time off as necessary under its existing policies and procedures. Employers can create new existing policies and procedures as long as those policies and procedures don't discriminate against one group of people or another based on some protected class. There are, of course, a myriad of laws, and most of them are at the state and local level that provide for sick leave in the event of employees who have illnesses or who have to care for family members who have illnesses that are qualifying under those laws. Query whether an employee's decision to have an abortion or the family member's decision to have an abortion would fall within that definition. There are laws that protect individuals who are pregnant and entitle those individuals to accommodations at the state and local level. But some of those laws, to the extent they exist at the state and local level, would specify either in guidance or in case law or perhaps even the statute themselves that an employee or an individual's decision to have an abortion and having the procedure itself would qualify as the type of condition or related condition that could entitle an employee to an accommodation. And on top of that, there are laws that generally protect from discrimination people who either are pregnant or people who make decisions with respect to their own reproductive health. Those laws tend to be a little bit more recent, let's say, than the other ones. But the real, upshot is that employers need to assess the laws in the jurisdictions in which they operate on the accommodation level, on the leave, meaning the sick leave level, and on the protection from discrimination level to make sure that you're complying with those various obligations. So, generally speaking, there are about 6 cities and states that we're aware of that have enacted laws that protect employees from discrimination based specifically on reproductive health decisions. That includes New York, the District of Columbia, Delaware, Hawaii, New York City. By first in New York, I meant New York State, and St. Louis, Missouri. Now, there may be others as well, and certainly in the wake of Dobbs, you're going to see laws being passed that likewise, I think, protect employees from discrimination based on reproductive health decisions. That means an employer can't, under those laws, take action against an employee because they've decided to make certain decisions with respect to their own reproductive health, i.e., have an abortion. But some of those laws may or may not extend to those individuals an accommodation obligation, right? That is different from and distinct from a prohibition on discrimination. So we'll just touch on a couple of jurisdictions quickly. In New York, in particular, the law does prohibit discrimination on the basis of an employee's sexual and reproductive health decisions. That is a fairly new statute in New York State, came out a couple of years ago, or maybe even last year. And state law similarly bans employment discrimination based on employees' reproductive health decision making. So in New York, there is statutory protection for individuals who make those types of decisions. That doesn't necessarily mean, at least under these laws, that there's an accommodation obligation, but it means that an employer is prohibited from mistreating or treating someone differently based on those decisions. With respect to leaves and accommodations, the city human rights law is one of those statutes in the country that does affirmatively require an employer to make accommodations on the basis of pregnancy. And the guidance that the city of New York issued in support of that statute makes clear that individuals who have terminated a pregnancy are entitled to reasonable accommodations from their employers. So at least in New York City, there is an accommodation obligation when it comes to employees who have decided to terminate their pregnancy. On the topic of state and city sick leave law, meaning are there laws that entitle employees to take paid time off in order to obtain or have an abortion? The answer there is there are state and city paid sick leave laws that require, as I'm sure many of you know, employers to provide employees with up to 56 hours of paid sick leave or safe leave each calendar year. That's sort of your standard run-of-the-mill sick leave requirements. And in the statute, there are a variety of permitted uses for those hours. One, of course, is the mental or physical illness, injury, or health condition of the individual, or for diagnosis, care, treatment of a mental or physical illness, injury, or health condition, or the need for medical diagnosis or preventative care. That's a pretty typical definition of, at least under these city and state sick leave laws, of a reason for which someone could take the leave. And frankly, there's a question, right, about whether having an abortion in and of itself would qualify for that type of sick leave. It may, certainly if it's a medical necessity, perhaps the recovery period might be also, but I think it remains to be seen precisely whether, taking time off to have an abortion, regardless of what state you live in or where you have to travel to get it, would actually require, an employer to provide sick leave. In this case, of course, in New York, right, the procedure itself is not unlawful, right? To the contrary, the state has recently passed legislation protecting the rights of women to have abortions. And so, the real question would then become if an employer in New York State or New York City has an employee who has to take time off for an abortion, is that going to be covered, by the state sick leave law? That doesn't mean that an employer can't cover that time with pay voluntarily through some other employer provided benefit. We also need to think about paid family leave law. So in New York in particular, the law prohibits, or I should say protects, an employee's ability to take time off on a partially paid basis for up to 12 weeks to care for a family member who has a serious health condition. So again, question whether having an abortion would qualify. Generally speaking, to have a serious health condition under the New York paid family leave law, one has to essentially be in inpatient care, hospital or hospice treatment, or undergoing continuing treatment or continuing supervision by a healthcare provider. So it's a very fact-specific inquiry. Again, I would certainly think that medical necessity, abortions born out of medical necessity, would be covered. Others, it's not, again, entirely clear, but to the same point I made earlier, employers could always decide to cover that time through other policies or practices. There is proposed legislation in New York State, Senate S7308A, which would provide for paid family leave following a pregnancy outcome, including abortion. So there's under consideration an amendment to more specifically state that if an employee or family member has an abortion, that it would entitle the individual employee to take paid family leave to care for that family member. In California, the law is somewhat similar in the sense that AB 1666 protects those in California from civil liability for providing, aiding, or receiving abortion care in the state. Of course, that was enacted in response to what would have been the Dobbs decision when it was previously leaked and people had a sense of what it was going to say. That statute was passed. The Contraceptive Equality Act in California, if passed, meaning it's not passed now, would prohibit discrimination against employees because of their reproductive health decisions. That's similar to the law that exists in New York. From an accommodations and sick leave perspective, like New York, the California Family Rights Act requires employers to provide accommodations on the basis of pregnancy. And the question of whether terminating a pregnancy would qualify is one that I think, if not already answered, is going to be answered in the guidance soon. Healthy Workplace Family Act, which basically is the state equivalent of the sick leave law in California, requires 24 hours of paid sick leave. And of course, cities and counties and states in California, Los Angeles and San Francisco among them, tend to offer even more than that, up to 72 hours or 56 hours, depending on the circumstances. And again, you'd have to look specifically at the reasons for an employee being allowed to take those statutory leaves to determine whether an employee either having an abortion or caring for a family member who's had one would qualify for those protections. Illinois is similar. Reproductive health discrimination ban is under consideration at the moment, but the Illinois Human Rights Act does require accommodation on the basis of pregnancy. And in particular, the Chicago paid sick leave ordinance gives employees up to 40 hours of paid sick leave for a number of reasons, like many other states and cities, including for preventative care, diagnosis, or treatment. So I think, from a statutory leave and accommodation perspective, employers should be thinking about, the jurisdictions in which they operate and whether there are statutory leave entitlements, accommodation obligations, or just anti-discrimination protections that they need to be aware of. At the federal level, you have the FMLA, which of course requires employers to provide job-protected leave for serious health conditions, including qualifying pregnancy-related conditions. From the federal FMLA perspective, the question of whether an abortion would qualify as a serious health condition, I think, will probably turn on whether it constitutes an illness, injury, or impairment, or some physical, mental condition requiring continuing treatment. That's the standard. And again, it depends on the circumstances of the particular case as to whether it would qualify. The Pregnancy Discrimination Act, again, at the federal level, prohibits discrimination on pregnancy, childbirth, or related medical conditions. That, too, doesn't specifically delineate abortion as being protected, but case law and guidance issued by the EEOC does make clear that abortion is considered a pregnancy-related condition on which you can't discriminate against someone. But the Pregnancy Discrimination Act doesn't, in and of itself, require employers to provide accommodations to pregnant employees. So therefore, again, you'd have to look to whether the federal law in other contexts, like the Americans with Disabilities Act, in the case of a pregnancy with complications, or like we looked at earlier in New York, would have a freestanding statute requiring accommodations in the event of an abortion. So the next thing to just focus on, which has to do primarily with federal employees, is that The OPM guidance that came out late last month does not reference abortion by name, but it does make clear that federal employees may use sick leave to travel in order to obtain medical care. And again, that was issued in June or late June of this year. We also got questions around discrimination. And so, can, for example, a male employee assert a sex discrimination claim because of their employer's failure to provide travel or medical benefits to accommodate certain conditions that are specific, let's say, to male reproductive health? I think that's difficult in the sense that discrimination against men for providing abortion-related benefits doesn't really seem to be a big issue, because the benefit that, at least the one that we've been talking about or that Jennifer's been talking about, is not so much based on gender as it is based on the actual procedure and the fact that you have to travel to a different state in order to get it. One would imagine that if there was a procedure that was banned in a particular state where an employee worked and that employee was a male, they'd have to travel, that might be a different story. But to the extent that there's not such a ban on an employee's ability to obtain a particular procedure in state, I think that is what kind of makes it a different set of circumstances. On the topic of religious discrimination, clients have asked, well, if an employer, can an employer discipline an employee who has religious beliefs related to abortion because the employee's workplace comments on abortion? Let's say those comments are born out of religious discrimination, a religious objection, let's say, to abortion. I think that employers have to be a bit careful there about, what they're doing and saying and how they're reacting to employees' reactions about abortion, particularly if born out of religion. Now, that doesn't mean that, the employee can themselves discriminate based on religion against other individuals, but I think an employer has to be careful when taking action, if it intends to do so, against an employee who has, let's say, spoken out against abortion and done so, sort of on the basis of his or her religious beliefs. With respect to hostile work environment, can an employee make a hostile work environment claim on the basis of an employer's statements or actions in support of abortion access? Possibly, right? Again, to the extent that an employer kind of espouses the right of an employee to have access to an abortion, and maybe particularly does so with reference or commentary on religion, for example, that could be an issue. And so I think in that context, my general advice to employers has been, if you're going to make announcements about policies that you're rolling out that touch upon abortion, the ability to travel and get, be compensated for the travel and the lodging associated with it, it might not be a bad idea to at least acknowledge publicly that there are differing views, right? And at least that acknowledgement opens up the door to, an employer being able to say, listen, we acknowledge that different views exist. Our company's values are as follows, and we're, willing to extend these benefits to individuals who need to travel out of state in order to receive that type of treatment. On the disability front, what protection does the ADA provide for employees who are seeking or obtained an abortion? Again, the disability has to be, at least at the federal level, a mental or physical impairment that substantially limits a major life activity. It's a fairly high standard. States and localities tend to have lower standards, but I think the question there becomes, whether the condition that brings about the need for an employee to have an abortion, let's say, for example, a medical condition that, makes the abortion necessary to protect the health of the mother, that underlying condition could certainly qualify as a disability, as it were, under the ADA. So, with that, I'll turn briefly to just the last topic that I wanted to touch on from an employment perspective, which is the subject of free speech. So, under the National Labor Relations Act, as I'm sure many of you know, employees are protected in their ability to speak and openly participate in concerted activity or engage in other conduct for mutual aid or protection. So typically this involves employees, talking amongst themselves about what benefits an employer is offering, what pay they're offering, how they're being treated by their employer. And so I think the question of whether this type of speech may or may not be protected under Section 7, hinges upon exactly what the speech is. It's going to be very fact specific. Is it the employee expressing their own views and opinions, or is it the employee complaining to others about a policy or a practice of the employer that impacts their terms and conditions of employment? I think the former probably not protected. I think the latter probably yes. But again, it depends more on the circumstances. And then just from a general free speech perspective, private sector workplaces are generally not subject to the First Amendment when it comes to free speech, but there are some states and localities that have legislation that do limit an employer's ability to prohibit certain workplace speech. And so if you live in a jurisdiction that has such a statute, you need to be thinking about that when it comes to restricting employees' speech about different topics. Those, I'd say, are the big picture topics that we've been speaking to clients about from an employment perspective. I'll say that the bulk of those conversations tend to focus more on benefits and makes a lot of sense. But those are the things that I typically touch on when an employer asks me, what about the employment piece?
Evandra, I had an interesting question come through, and it really asked if you could speak to the aid and abet laws as applied to providing leave. And let's just think of it in a situation where possibly the employer is not funding the travel to another state, but they are providing leave for an employee to travel to have an abortion in another state. Would those aid and abet laws still apply?
Yeah, they could. I mean, listen, I think the answer is they definitely could. You'd have to look very specifically at the language of the statute to kind of determine whether it falls within that rubric. And, then you'd have to think about whether, what you're doing by providing some form of paid leave, would constitute aiding and abetting under the language of that particular statute, keeping in mind that I think employers, are kind of on the fence about obviously wanting to provide this benefit and do what they think is best for certainly for their workforce, but at the same time, not necessarily subject themselves or open themselves up to risk of liability on a state law issue. So, it really depends. It's the typical lawyer answer on the language of the statute. It depends on the employer's, tolerance for risk. It depends on, what and or how the statute has been enforced, in the past, or what it looks like, the state's regulatory enforcement appetite is going to be. But I think the answer is, yeah, that's certainly possible.
Chase, if you would like to, we only have 3 minutes left. If you want to ask any additional questions, and then tell the audience about the resources that we have before we turn it over to Amber to close it out.
Yeah, just one more question. That you mentioned the state regulatory and all those things that could potentially the factors that could come into play. But employers are, particularly multi-state employers, are now kind of up against this huge task of being able to or having to track state law changes, and some of them are going to be slower, some are going to be more quick. What's your advice towards to employers that are sort of up against that task? Are there any great resources for it, or is it any tips at all, or is it just kind of you're just going to have a huge tall task?
Yeah, no, unfortunately, I think there is just a big task of pulling all that information together. I'm not aware of a one-stop shop. Unfortunately, as you can imagine, and this was certainly the case in COVID, times as well, right? With different states and localities having myriad legislation and regulations and guidance that was changing, by the day. I think it is going to be a tall order to sort of pull that information together and monitor what is going on. Obviously, we've been doing that with and for our clients, and it's something that lots of multi-jurisdictional clients have been focused on. And so, I think it is a tall order, but service providers, law firms, Proskauer certainly has been doing those types of things for our clients and keeping track of them.
Yeah. It's just a huge, tall task. And it's, big challenges. So, Evandra, Jennifer, thank you so much for walking through this. This has been extremely helpful, and we appreciate your insights and your responses to questions. Thank you, everybody, for your questions. We had a lot come through in the Q&A and tried to get to all of them. I'm not quite sure if we got to every single one, but we did want to mention really quickly that we'll be following up with the webinar and slides, as well as our own NFP resource on this issue that kind of recaps primarily the reimbursement arrangements and the other coverage options that Jennifer kind of went through. But we will follow up with that. And again, thank you, Evandra and Jennifer, and I'll flip it back over to Amber to close us out.
Thank you to our speakers for sharing your valuable time and expertise with us today. To reiterate, today's presentation was recorded. We will be sharing the recordings in the follow-up email and on the NFP website. If there are any portions of this call that you missed, by Monday, you will receive an email with link to the full recording. The PowerPoint slides used during this presentation will be shared in the same email. At the end of this call, a survey will populate in a new window. Please take a brief moment to complete this survey as it lets us know what topics are important to our listeners and helps make our education program as current and relevant as possible. That concludes our webinar for today. Thank you everyone for joining us and have a great day.